Shortly after learning of OFAC's designations of Abramov and Perevalov, Sinyavsky initiated a scheme on their behalf to transfer nominal ownership of their properties into the names of their non-sanctioned family members. This is a common technique used by the Russians seeking to circumvent the sanctions. Actually, they used to do this before even the war started.
Global companies face unprecedented risks and challenges in today's economy. To mitigate these legal and economic risks, companies are rapidly embracing and elevating the importance of robust ethics and compliance programs to promote positive corporate citizenship. On Corruption, Crime, and Compliance, you'll hear from industry leaders and insiders about how to create effective ethics and compliance programs that will mitigate risks and maximize financial performance. Here's your host, Michael Volkov.
Welcome, Michael Volkov here for another episode of Corruption, Crime, and Compliance. Today we're going to look at one of the first OFAC enforcement actions, actually the second of the year. The first was Haas. The second was Family International and owner paying about a little over $1 million to settle violations of the Russia sanctions program. This is connected to a criminal case and a criminal prosecution, and we'll get into that as well. Family International is a Florida real estate company, and its U.S. owner, Roman Sinyavsky, settled with OFAC for $1.07 million for 73 violations of the Russia sanctions program. In a separate criminal case, Sinyavsky pleaded guilty to circumventing U.S. sanctions and money laundering. So between 2018 and 2023, Family International and Sinyavsky transferred nominal ownership of 3 luxury condominiums owned by 2 sanctioned Russian oligarchs, Valeri Abramov and Viktor Perevalov. And they transferred them to their non-sanctioned family members and to shell companies owned by those family members. Miami International earned $182,000 in commission fees and reimbursements through rentals of 2 of the properties to third parties on behalf of Perevalov and the sale of the third property on behalf of Abramov. Now, OFAC sanctioned Perevalov and Abramov for conduct involving a Russian-based construction company that was responsible for constructing the Tavrida highway in the Russian-occupied Crimea region of the Ukraine. Perevalov was designated again by OFAC in December 2024 for operating just generally in the construction sector of the Russian economy. Sinyavsky maintained long-standing financial ties to both Abramov and Perevalov. He provided property management services for Abramov's and Perevalov's respective South Florida condominiums, exercising power of attorney over Perevalov's bank account and acting as the care-of party for at least 3 bank accounts that were jointly owned by Abramov and Abramov's spouse. Prior to and at the time of the OFAC designation, Sinyavsky had been renting out his luxury hotel rooms 2 condominium units jointly owned by Perevalov and his spouse, and was attempting to broker the sale of another condominium unit jointly owned by Abramov and his spouse. Let's look at the Abramov designation and what happened. Shortly after learning of OFAC's designations of Abramov and Perevalov, Sinyavsky initiated a scheme on their behalf to transfer nominal ownership of their properties into the names of their non-sanctioned family members. This is a common technique used by the Russians seeking to circumvent the sanctions. Actually, they used to do this before even the war started. Roman Sinyavsky understood that OFAC's designations meant transactions involving Abramov's and Perevalov's properties were prohibited and therefore sought to conceal their ownership interests. His conduct was designed to remove the 2 designated oligarchs' names from their property titles, to obscure their ownership interests and facilitate the rental and then future sale of the properties. OFAC cited Sinyavsky's text messages to confirm his knowledge of Abramov's designation and the nature of the restrictions. Just hours after Abramov was designated, Sinyavsky warned Abramov via text message that it will soon be forbidden to deal with you. I talked with people who know about this issue here. Nevertheless, Sinyavsky continued contacting potential buyers in an attempt to prevent OFAC's sanctions designation from impeding a future sale. To escape detection, Sinyavsky and Abramov sought to transfer ownership of Abramov's condominium from joint marital property to Abramov's spouse alone with the intent of concealing Abramov's continued property interest. Sinyavsky worked together with a law firm to deed the property, valued at over $1 million, to Abramov's spouse for $100. I also wonder what happened with that law firm. I'm sure that law firm was cooperating in this investigation. Roman Sinyavsky attempted to sell Abramov's condominium unit in late 2018 for $1.1 million, but the sale ultimately didn't come through. Following a new cash offer for the unit by third parties in January 2019, Sinyavsky hired a new attorney to complete the sale, and Sinyavsky and the attorney facilitated the sale of Abramov's property to the third parties in March 2019 for $1.2 million. The company earned a commission on the transaction and reimbursement for expenses previously incurred by Sinyavsky to maintain the property. Now, the Viktor Perevalov case was also interesting. Shortly after Perevalov's designation, Sinyavsky called Perevalov to inform him of his sanctioned status. And soon after that, Sinyavsky agreed to act on his instructions to conceal the ownership interest in his 2 South Florida condominium units by removing Perevalov's name from the property title in order to continue to generate revenue from them and potentially facilitate their future sale. Now, in furtherance of this scheme, Sinyavsky worked with the first law firm to incorporate a Delaware shell company and transfer nominal ownership of Perevalov's condominium units. The shell company was owned by one of Perevalov's non-sanctioned minor children and was managed in part by Roman Sinyavsky, and his spouse transferred nominal ownership of their properties without consideration to the shell company in June of 2018. Now, following this transfer, and with Perevalov's interests now concealed, Florida International and Sinyavsky continued to rent out the property as luxury hotel rooms until 2023. And from March of 2018 to March of 2023, Florida International and Sinyavsky rented or attempted to rent the properties on 64 occasions, generating or attempting to generate approximately $840,000 in rental payment revenue for the shell company. Now, the importance of this case, I guess, and OFAC emphasized this, was the importance of the role played by gatekeepers, including here you have a real estate management company, Florida International, Sinyavsky, who was part of this and ultimately pled guilty and will do jail time. The gatekeepers included these folks, and I would also argue that the law firms that were involved with these transactions obviously should have raised red flags in terms of their participation in these transactions. I'm sure they just cooperated with the Justice Department's criminal investigation and with OFAC. But normally these gatekeepers include realtors, investment advisors, attorneys, trust and corporate service providers that can enable sanctions evasion. Such professionals possess unique expertise and technical know-how. In other words, they know better. That enables them to provide critical business service. However, as demonstrated in this case and other recent actions, OFAC noted that these services can also be misused to conceal a sanctions party's interest or evade sanctions compliance controls. OFAC also noted the fact that significant sanctions risks are associated with commercial, residential real estate transactions. In recent years, the Department of Treasury has highlighted these potential risks in an effort to arm individuals with the knowledge needed to identify sanctions evasion and to avoid dealing in blocked property. In particular, the Financial Crimes Enforcement Network, FinCEN, and the Multilateral Russian Elites Proxies and Oligarchs Repo Task Force have published numerous alerts, including specific red flags associated with sanctions evasion and particularly real estate transactions. So always be careful with regard to those and look for red flags. This is the second OFAC action. We've seen this here so far. The first was Haas, which we've written about on our blog. We're going to see more, as I said and have predicted. This is going to be a big sanctions year. If anything, we've seen some preliminary indications of a tightening of the Iran sanctions. We have not seen any relief yet with regard to the Russia sanctions. That will take a little bit longer, it seems, given statements recently made by General Kellogg who has been assigned to this task by the Trump administration. This may take time, but we shall see and stay abreast, obviously, of sanctions, export control enforcement, and see what the latest trends are. But it's a key risk for this area, and we'll keep you posted on more decisions and more actions as they come out and more guidance. Thanks again, and we'll see you next week for another episode of Corruption, Crime, and Compliance.
If you enjoyed this episode, the best way to support the show is by subscribing on your favorite listening platform. To learn more and connect with Michael Volkov, go to volkovlaw.com.